The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain where to file a guardianship proceeding for a disabled adult. So this will deal with terms called jurisdiction and venue. Jurisdiction is which state is appropriate to file the proceeding in, and venue is which county within the state, and we'll explain both of those things. So let's talk first about which state has jurisdiction over guardianship proceedings. The baseline rule is that the disabled adult's home state has jurisdiction, and this means it's a term of art. It's the state in which the disabled adult has lived for 6 consecutive months prior to the filing of the guardianship proceeding. Temporary absences such as vacations count towards this 6-month period. If the disabled adult does not have a home state, meaning that they haven't lived in any one particular state for the 6 months leading up to the guardianship proceeding, then any state with a significant connection to the disabled adult can assert jurisdiction. Significant connection is another term of art, and courts have to determine which states have a significant connection with a disabled adult. And we'll talk about how that works in just a second. Also, another situation in which the home state might not be the state that has the guardianship proceeding is when the home state determines that a different state with a significant connection is the more convenient forum for the guardianship proceeding. So it depends on the circumstances involved, but sometimes the home state might not be the most convenient forum for all the parties, and in that case, another state with a significant connection can assert jurisdiction. So courts are instructed by the Uniform Guardianship and Protective Proceedings Jurisdiction Act to consider the following factors when determining which state is a significant connection state. So we'll go through these factors one by one very briefly. One factor is the location of the disabled adult's family and other people who are entitled to notice of the guardianship petition being filed. Another is the length of time that the disabled adult was physically present in the state in question and any time in the disabled adult's life, and the duration of the disabled adult's absence from that state. So they're obviously not present there now in that scenario, or they might be, but it hasn't been for a consecutive 6-month period. The location of the disabled adult's property is another factor, and the most nebulous one is the extent of the disabled adult's ties to the state, such as voter registration, driver's license, social relationships, and receipt of services. So even if the other factors aren't present, if the disabled adult has significant other connections within the state, it might be a significant connection state, and that's kind of an open-ended factor. Even if a state is not a home state and does not have significant connection to the disabled adult, that state can assert emergency jurisdiction. An emergency jurisdiction is just on a temporary emergency basis for a disabled adult that's physically present in the state, and this is usually for the purpose of protecting the disabled adult in the short term until a guardianship proceeding can be filed in a different state. The emergency jurisdiction the orders that are granted based on emergency jurisdiction have a maximum life of 90 days. So an order can't be in place for more than 90 days if it's granted on a emergency jurisdiction basis. In this case, whoever wants to be appointed guardian will have to go and file in an appropriate home state or significant connection state after that 90 days expired, or preferably before it expires. So that's what you need to know about jurisdiction. It's pretty simple. First, we look for the home state, and then if there is no home state, or if the home state finds that it's not the most convenient state, then we look for a state with significant connection, and any state in which the disabled adult is physically present can assert emergency jurisdiction, even if they're not the home state or a state with significant connection to the disabled adult. Now let's talk about venue very quickly. The baseline for venue is the county in which the disabled adult resides, within a state with jurisdiction. So once you've established that the state has jurisdiction, then you find the county of residence of the disabled adult, and that's the appropriate circuit court in which to file the case. If the disabled adult does not reside in the state, the appropriate venue is the county in which the disabled adult's real estate or personal property is located. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below the video on our YouTube station. If you found this helpful, please subscribe to us wherever you listen to your podcasts or on YouTube, or you can subscribe to our email list at learn-about-law.com, and you'll be notified of our daily article and video posts. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.